Your phone rings, it's the day after the crash, and the person on the other side, well, they sound friendly and professional. They say that they're from the insurance company and they just need a quick statement so they can get your claim moving. You answer their question, you're honest and cooperative, and you just made the first mistake that can destroy your case. I am Asthana, managing partner at Caldwell Wenzel Asthana Personal Injury Lawyers. In the next few minutes, I will walk you through 5 specific decisions that injured Alabamians make in the weeks after a crash. Decisions that may seem small and feel harmless, but permanently reduce or eliminate what they recover. Every one of them is preventable, and every one of them could be permanent once that decision is made. Mistake number 1, that call from the adjuster, that's not a courtesy call. That is an investigation. They're asking open-ended questions because they want you to talk. Say things like, I don't think I saw them, or maybe I was going too fast. Here's why that matters in Alabama more than anywhere else in the country. Alabama follows pure contributory negligence, and there are only a handful of states that still use this rule in our country. And here's what it means. If you are found even 1% at fault in causing an accident, you and your claim are permanently barred from making a recovery. Not reduced, barred. That phone call from the adjuster, that's very strategic. They're trying to get you on that 1% fault rule. That one sentence from you is all they need. The right answer when they call for a recorded statement is very simple. Thank you for reaching out. My attorney will be in contact with you. That's it, nothing else. Marcus was rear-ended on I-65 near Hoover. He told the adjuster that he may have drifted slightly just before impact. His attorney spent months trying to overcome that one sentence. Had Marcus said nothing, that insurer would have no basis for an argument at all. One phone call can mean permanent damage. Mistake number 2 is to accept the first offer. The first offer almost always arrives before you even know the full extent of your injuries. It's designed to arrive then. The insurance adjuster knows that before you've had a chance to finish treatment or see a specialist, you have no idea what the true value of your case is. But once you sign that release, your case is closed permanently, notwithstanding what your doctor may find next month. There's a concept in personal injury law called maximum medical improvement, or MMI. It's the point where your treating physicians can tell you that your treatment injuries have stabilized and what does future care look like. In most cases, no experienced attorney will ever send a demand letter for your case before you reach MMI, because until you reach it, you don't know what your case is actually worth. Jennifer was rear-ended in Baldwin County, Alabama, suffering from back pain and neck soreness. The insurance company offers her $7,200 within 3 weeks of the accident. She accepted right away. She was thankful because she was worried about her bills. But unfortunately, 2 months later, her pain continued and her MRI showed a herniated disc requiring surgery. This diagnosis took her total medical cost to $47,000. But she had already closed her case. The insurance company, they knew that this individual was badly hurt. They knew that the MRI had not come in yet, and that's why the offer came within 3 weeks. Do not touch that offer until your treatment is complete and your attorney has had time to review your full medical picture. Mistake number 3 is gaps in medical treatment. Every delay or gap in your medical treatment allows the insurance adjuster to argue a few things. 1, your injury was not serious enough to require consistent care. Or 2, that your condition has already healed by the time you stopped. So anything that came later was not related to the accident. Either argument reduces the value of your case, and both arguments were preventable. Gaps can happen for various reasons: scheduling, finances, or temporarily feeling better. The insurance company does not care about your reason. They care about what's in the record. If you need to reschedule an appointment, then reschedule, but don't cancel it. If medical cost is what's preventing your treatment, then speak to your lawyer because they have options for you. MedPay coverage, medical liens, or medical funding companies exist specifically for these reasons. David was injured at an intersection in Mobile, Alabama. He felt improvement at month 2 and stopped physical therapy, but his symptoms returned in month 5. The insurance adjuster argued that his injuries had resolved, and his current condition, that was unrelated to the crash. The gap gave them a medical timeline they didn't have before. Consistent treatment and following your doctor's orders eliminates the argument completely. Mistake number 4 is posting on social media. Defense attorneys and insurance adjusters, they monitor your social media. Not occasionally, but routinely and systematically. A single photo can eliminate months of documented limitations. A beach trip where you're standing or holding a child at a cookout. A night out where you look happy and healthy. None of these things necessarily mean that you weren't hurt, but all of them can be used to show exactly that. And it doesn't have to be just your post. If you're tagged in others' pictures, those count too. Lisa was injured in a Pensacola, Florida crash, and she claimed to have suffered injuries to her shoulder. 2 weeks later, her cousin tagged her in a photograph where she was holding a toddler. The insurance company's attorney uses that photograph to challenge her limitations at a deposition. That photograph does not prove that she wasn't injured, but it casts a doubt. As hard as this could be, reduce all social media activity after the accident and until your case resolves. And the last mistake is not knowing your own insurance coverage. Most people after a crash think about only one policy, the at-fault driver's insurance policy. That's the coverage that is supposed to pay for all the damages caused. But the at-fault driver's policy has a limit. In Alabama, the minimum limits are $25,000. For a serious injury requiring surgery or months of lost income, $25,000 does not even come close. Here's what most people don't know. They may have coverage under their own insurance policy, which is designed to cover exactly this kind of a scenario. Alabama requires insurance companies to offer their insureds what's called underinsured or uninsured motorist coverage to every policyholder. This is a coverage that most people have, they just don't know they have it or how much it is. This is also referred to as UIM or UM, which steps in when the at-fault driver does not have any insurance or very little insurance to cover all the damages caused to you. Your own insurance company will pay up to the policy limits of this coverage. There's also what's called MedPay, medical payments coverage. This coverage will pay for your medical bills whether you were at fault or not, and most people, well, they don't think about checking for it. Robert was in a serious crash near I-10 in Mobile, Alabama. The at-fault driver had $25,000 minimum limits in Alabama. Robert assumed that his case was over, but his attorney, they found additional $100,000 under Robert's own coverage for UM or UIM. Pull out your declarations page right now. Know your UM/UIM limits. Know your MedPay limits before you need them. Every one of these mistakes is preventable. Most of them could cause permanent damage to your case. If you've already made one, that does not mean that your case is over. But the sooner you get an attorney involved, the more options you will have to fight it. And if you haven't made any of these mistakes yet, well, now you know what not to do. If you need an attorney, you can call us anytime. There is no fee unless we win for you. We have offices in Mobile, Birmingham, Foley, Alabama, and in Pensacola, Florida, and we will come to you if you can't come to us. Don't forget to like this video and subscribe so you don't miss our next video about who pays if you were hurt in a rideshare accident. Thank you for watching.